1, 2, 3, 4, 5. Alright, I have this on Wednesday, June 22nd. I asked Robert if I could use his notes to talk about on a video, and you can see in the bottom it's 1.24 megabytes. That's what I originally asked him if I could use those notes, and he told me that he would make special notes that I could use on a video. And so you can see the 2.09 megabytes is what he said I could use for Travis to lawyer. It looks like he added a little bit more information, especially for me. And I didn't really make any comparisons. I don't know exactly how that's how there's how much of a difference there is. So here he is. He's given comments for me to share with I think the audience is what he's saying. Travis did not arrive at the library and start setting up cameras. Davis testified otherwise. None of the cameras came out until the police arrived. Many people have smartphones with cameras, and most laptop computers have cameras. These common items can't raise suspicion. Let me also add that some of this information my lawyer Phil did not add. So these are suggestions. Not all of them were added to my writ. Librarian call to dispatcher transcript. Insert 35-second hold time. Yes, I measured it. Emphasized the non-emergency aspect of the call. Somebody said Travis brought out a second GoPro. It was only the one. I do not like the argument that librarians' fear of a possible shooting is overactive imagination. I think it's more important to impeach the lady librarian with her growing fear over time, starting with not wanting you banned or arrested, but just wanting you to see a police presence, and growing to hysterical proportions, so I would attack the very existence of the fear. I think there was never fear of a shooting at all. Come on, the dude librarian was following you around, watching you. He wasn't scared. He was curious. The Davis police report should have been admitted into evidence. Travis did try to impeach Davis with his report, but the judge improperly disallowed the questioning. So if you're challenging the sustained objections, it seems you should be challenging the denied evidence too. And Davis admitted that his police report was not his version of events, but rather a recitation of the lady librarian's written statement. And then it could only have been her first lost statement, because her January 25th written statement doesn't have all those details Davis swore to. All of this places their testimony way beyond reasonable doubt of being true. The lady librarian did not really agree with the dispatcher that Travis was suspicious. Instead, when the dispatchers asked, "You said somebody was acting suspicious?" Librarian clarified, yes, he's acting very strange. Some have used the phrase reasonable suspicion of a crime, but the hardliners argue that the police don't need to have a statute in mind. So I would use the phrase reasonable suspicion of criminal activity, because that is how high courts have interpreted it. For example, cops don't need the elements of the larceny or vandalism statutes. They can say, we thought he might try to take something or damage something. Emphasize lady librarian's changing story. She testified about shaking on doors and checking emergency exits. Need to impeach on those. Otherwise, hardliners just say a witness provided testimony about shaking and rattling doors, and she heard him shaking the emergency door. On this overplayed A Place Where Children Gather drama, note that there was a magazine cover with a large-breasted woman in a bikini top is visible on the magazine rack. This was hardly a children's section. There was no evidence children were even allowed on the second floor at all. While I have argued in the Pig Traders video, Travis Hines ain't guilty, that Louisiana's Criminal Code Procedure 218.1 makes it required that officers state fully the reasons for the investigation. I fear that hardliners will simply say that detained in that code just means the same as arrested, and that it doesn't mean investigative detention. Seems disingenuous, I know, but there are ways to game around this statute, and the opposition will probably try. I just don't want to put too much hope into one argument. Not once in any of the hearings did Sea-Dog or the judgelet call Travis a journalist. Judgelet even made some comments that you were not the media, if I remember right. Sounds a lot like show us your press credentials. Mass shooting bags need to point out at least that this evidence was not communicated to the police before the arrest. Banging noises not communicated to the police before the arrest. Don't try to justify the action of checking doors. I don't think Travis did any of what the librarian said. Impeach checking doors. Don't justify it. Dude, librarian video interview said he looked the door up and down. Lady librarian video interview said he touched it a little like this. Lady librarian in trial said she couldn't see the door, but she heard Travis shake it. Detective Parrott asked her about other doors, and she was unable to describe any. We're talking about one door that Travis looked at. Third floor, a simple direction. Sir, you can't go up there. Would have solved the problem. I really want to question Parker's credibility on green army jackets, and the officer's credibility in avoiding the language. Again, see, Travis Hines ain't guilty. Davis' report was wildly inaccurate based on his own body cam, and Davis admitted that the report was based on a later written statement by Parker that was never introduced at trial because the police lost it. While I do think that Travis was de facto seized and arrested by the very nature of the officer's positioning preventing his departure, I don't think a conservative appellate court would like this argument. I will need to read some more law on that, but they won't like that the cops accidentally arrested Travis before they wanted to. It depends on how closely the judges will actually follow constitutional precedent. I think it would be better to state the argument as in the alternative and let the judges run with it if they agree. Davis testified that the suspicion led to a necessity of finding Travis's name. This may be too subtle, and if he needed a name, he needed it to incriminate Travis. Hibble addressed this directly. A state may legislate that a lawfully detained individual must provide his name except if providing his name violates his Fifth Amendment rights. It seems that the only reason Davis wanted a name was to use it against Travis, and this exactly matches up with why 218.1 would require Davis in that context to inform Travis of his Miranda rights before asking even the simple "what's your name" question. Everything I wrote above about Davis's report applies also to Miller's. His report mentions things from Lady Librarian's statement, things he admitted in trial he didn't know about before arrest. In the statement of facts, if it's allowed, you might 1. Describe the library as a former bank in stunning space, worthy of admiration, with 3 stories in atrium style with high windows and ceilings. This is partially in evidence. Jimenez described Travis as looking up, looking around. Perfectly consistent with a new patron examining a wonderful space. Even if not admissible, judges might actually know the building. Here's how I would summarize the events. Instead of using page space to include the transcripts verbatim, the caller reported a patron that's acting very strange. After placing the caller on hold for 35 seconds, the dispatcher, a trained member of the police department, returned and asked, "You said there's somebody suspicious?" To which the caller clarified, yes, he's acting very strange. The caller went on to describe the person as, 1, checking all doors and everything, I don't know. White male, about 6 feet tall, and he had a green army jacket. The caller provided other details that were not ever relayed to the officers by the dispatcher. The dispatcher relayed to officers the 4 numbered facts above, plus acting suspicious like he's casing the library, checking the doors to see which ones are locked and which ones are not. Upon arrival at the library, per body-worn camera, the only additional information provided to officers by the caller herself was a 5th item. He tried to go up to the 3rd floor and he checked our emergency exits. In summary, the totality of objective information fairly in the possession of officers were the items 1 through 5 above. The officers also had conclusory commentary from the dispatcher, and any departure from the actual words of the caller must be labeled subjective. Similarly, summarize, don't recite. The entire police Travis pre-arrest encounter. The pre-arrest encounter encompassed 2 minutes x seconds. During this encounter, police asked no investigative questions. Police offered no explanation for why Travis was being investigated beyond a call about a suspicious person. The prosecution essentially argues nothing more than that Travis is morally wrong. The danger posed to Travis by this approach is this: as Owsley did, the appellate court may, as a first step in its decision-making, latch onto the story that Travis is morally wrong. The court could then take a results-oriented approach and fashion a disingenuous description of the facts in order to fit a correct ruling on the law per those false facts. This is harder to battle when, in fact, your defendant is morally wrong, and you're only arguing that he is legally right. Such is not the case here. Travis is morally right, and you can start your argument with that as a lead-in to the legal arguments. Further, you can directly attack and discredit the prosecution for making no correct legal argument, but rather relying on a weak and false moral argument. This is just another writing I prepared earlier about topic above. Sorry for the repeat, but if you could forward this, the one that fits you better. Travis was not ever setting up cameras, preparing for a police encounter. When police arrived, by Davis's admission, Travis' laptop screen was not recording video. It was only after Davis arrived that Travis then switched his laptop to video recording, and he repositioned the laptop to catch both Davis and Favors on the screen. So Travis's initial video recording was simply with his smartphone. This is an ubiquitous usage of a smartphone. Travis's quick response in bringing 2 other cameras into action, laptop camera and GoPro, from his pocket, were nothing more than the actions of an experienced journalist. This behavior is far from the setting up camera equipment claimed by the prosecution. I don't see any harm in setting up his cameras, but since that's provably by Davis's testimony not what Travis was doing, it seems wasteful to argue a justification for setting up cameras, as I think I have argued previously. Call out this hypocrisy. Owsley would not subject the police to a law school exam, thus preventing Travis from asking questions about the statutes. When Sea-Dog objected to a Travis question and that objection was not sustained, Owsley reacted not by overruling the objection, but by subjecting Travis to a law school question. Why are you entitled to ask this question? When Travis answered wrongly to a question he should not have been asked, Owsley found reasons to sustain the objection. There is no requirement to rebut an objection. An objection is not a motion requiring an opposition. There's big worry that Travis's questioning on Davis's report introduces evidence rather than impeaching it. This needs to be dealt with. Travis is intended to argue in closing arguments that the body cam contradicts Davis's report. In his testimony about the report, arguing that the information didn't come from Parker at the scene, but rather from Parker's later post-arrest statement. But that argument came unnecessary when Davis admitted in his own testimony at minute 141:23 that this is again what she wrote on her statement, she put in her statement. Davis is admitting that everything he's been reciting as his sworn statement is exactly a recitation of Parker's January 25th written statement, which is in evidence. But there may be some Davis answers that were set up for impeachments that didn't get impeached. Because of the judgelet's improper sustaining of objections, we might need to go back through Davis's testimony to avoid this pitfall. I still like Travis's closing argument. Miller was the arresting officer. Miller admits he had only dispatched information available, and he even got that wrong, testifying about facts he only learned later. He did not talk to any librarian. He did not hear any investigative action by Davis Favors because there wasn't any. Seadog reacted in trial after Travis's closing by lying about Miller's testimony and even making reference to Miller's statement that he himself had objected out of evidence. The green army jacket, Alabama versus white. A caller is right about one thing, so the caller is probably right about other things. Use the inverse. A caller is wrong about one thing, so the caller is probably wrong about other things. Do not admit to public outcry causing phone calls to Parker. No evidence was presented to those calls came from anybody associated with Travis. If we look objectively at who stood to gain from calls threatening Parker, the answer is clear. The prosecution, who could then point the blame to Travis, and the police, who stood to avoid civil rights violation damages if Travis was convicted. No evidence was presented as to who made threatening calls, and a reasonable jury would have had reasonable doubt that it was anybody other than those who would gain from the action. There is no evidence that Parker filed a complaint with the police about threatening calls, or that the police, the same police who stood to gain from making the threatening calls, investigated the source of those calls. The librarian's video interviews have only exculpatory value, because they were not shared fully with Travis. He was prejudiced by lack of preparation, and any failure to object to any presentation of the videos in the prosecution's favor must be excused as a result of that prejudice. Likewise, any refreshment of memory of witnesses gained by the playing of those videos must be disallowed, as must any testimony in conjunction with that refreshed memory. The prosecution may not be allowed to gain any advantage by this withholding of evidence. This leaves the prosecution with nothing from witnesses Parker and Jimenez, because in both cases their video was available to them in preparation for trial. With the city fearing repercussions from fully producing the video statement to Travis, there was one proper avenue to address those fears: a discovery protective order, prohibiting Travis from publishing the video. Instead, the city chose a tool of tyranny withholding exculpatory evidence from the accused. Sorry, some of this is repetitive. Alright.